Hello everyone. Today in this lecture segment, we will be covering part 3, 4, and 4a of the Constitution. Part 3, 4, and 4a constitute and concretize the lofty goals of justice, liberty, equality, fraternity, dignity of individual, which are set out in the preamble. They are imbued in the dominant theories of human rights. We may classify these three respectively as negative obligations, positive obligations, and duty of individual. Basically, these are the part 3, 4, and 4a divided in the Constitution. So, negative obligation deals with the state's obligation to not to interfere with the liberty of the individual. Same way, positive obligations is the state requires the state to take steps toward the welfare of the individuals, which we'll study in various articles regarding DPSPs. Now, third is the duties of the individual towards society and its fellow beings, which are covered under Part 4A, which were added through 42nd Amendment. So basically, today we will start with fundamental rights, which are covered under Part 3. Part 3 and 4 can also be differentiated on the basis of enforceability and non-enforceability. For enforceability of Part 3, articles under Part 3, you can go to the courts. However, we cannot go to the courts for the enforceability of the Part 4 articles under Part 4. Now, Part 3. Today we'll start with Part 3, and then coming lectures uh, will cover the respective Part 4 and Part 4A. So, Part 3 is about the fundamental rights. Fundamental rights are like noble pedigrees. We can also call them as natural rights, which are very inherent and they command higher sanctity than other rights. That is why they are called the Magna Carta of the Indian Constitution. In to grasp the uh, concept of fundamental rights, we can consider the case of Menka Gandhi, in which Justice Bhagwati uh, has observed that these fundamental rights represent the basic values cherished by the people of this country since the Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent. And that is why they weave a pattern of guarantee on the basic rights and impose negative obligations on the state to not encroach or interfere with the liberties of the individual. However, any uh, there are no absolute freedoms. There has to be some restrictions on it. For that, we'll have to go through the historical perspective. So, Parliament of England is considered that they suffer no limitation. It is said that in Parliament of England are so supreme that they can, apart from converting from man to woman and woman to man, they can do anything. That Parliament has no limitation. So, a legislation brought in Parliament of England cannot be annulled on the grounds of violating liberty. But that is not because they take away. That is not because they cannot take away liberty. This right has been given to them because of its long tradition of being the champion of the liberty. However, situation is not same in our country, so there are some restrictions and or suspension of fundamental rights in some cases. Because I've already told that absolute and unrestricted individual rights do not and cannot exist in any modern state. Same way, the Constitution has provided some reasonable restrictions on individuals' liberty in the interest of the society. So we can, to understand this in better way, we'll consider the case landmark judgment under A.K. Gopalan versus State of Madras in 1950, in which Justice Mukherjee has observed that there cannot be any such thing as absolute and uncontrolled liberty, wholly freed from the restraints for the that would lead to anarchy or disorder. And That is why he said that the possession and enjoyment of all the rights are subject to such reasonable conditions as may be deemed by the governing authority essential to the safety, health, peace, general order, and morals of the community in the power. What the Constitution therefore attempts to do by declaring the rights of the people is to strike a balance between individual liberty and social order. It was also enumerated in the case of PUCL versus Union of India in 2004 that courts generally respect the legislative policy behind valid legislation which imposes reasonable restrictions. So, today we covered what are fundamental rights, how they are noble, and they are considered why they are considered natural rights inherent. They are inherent and command superior authority over other rights, and a few cases like Menka Gandhi and A.K. Gopalan and PUCL versus Union of India. Now, in the further lectures, we'll cover uh, the articles of related to fundamental rights one by one, and after that, the DPSPs and fundamental duties. So, wait for the next videos. Thank you.